Hi, good evening, everyone. Welcome. Today's panel, Mr. Naavi and Advocate Ranganath will be discussing two historic cases. Suhas Katti case was the first criminal conviction under ITA 2000, which occurred in the year 2004. It was also the first case in which Section 65B certificate was admitted as an evidence and Naavi had presented the evidence. Umashankar versus ICICI Bank adjudication was the first instance of adjudication under ITA 2000, resulting in the liability of the intermediary bank being upheld in a phishing case where both Mr. Naavi and Advocate Ranganath were involved. Before moving on to the session, I wish to mention the event which happened in Chennai last week. On 17th December, Cyber Society of India conferred a Lifetime Achievement Award to Naavi for his contributions to cyber jurisprudence. Naavi and three others who were instrumental in the first conviction under ITA 2000, the case we are discussing. High Court gave away the awards in the presence of several dignitaries. Advocate Ranganath, who argued the Umashankar case in the Madras High Court, was also felicitated in the same function. We at FDBP felt today is an occasion to celebrate this achievement and an opportunity to congratulate Naavi sir and appreciate his contributions. Many congratulations, Naavi sir, and many congratulations, Ms. Advocate Ranganath. Now I invite Mr. Durai Kanayan, who represents Cyber Society of India, to talk about this award and its recipients.
Yeah. Am I audible, madam?
Yes, you are audible.
First of all, let me congratulate our Naavi sir for the Lifetime Achievement Award, and also Ranganath sir for the guest of honor. Before I talk about the award, I would like to say a few words about the SAIC. Most of you might have already aware of or know about SAIC. But still, I would like to mention a few notes about this. Cyber Society of India, a not-for-profit organization, was formed in the year 2004 in Chennai by the cyber enthusiasts to create awareness on cyber safety or cyber security. Our Naavi sir was the founder secretary of this association along with many other people from government, private sector, and banks, advocates, IT professionals, and many other people. Since then, SAIC, Cyber Society of India called SAIC, has been actively conducting, making many activities, programs on cybercrime, IT acts and regulations, and other cybersecurity related topics. With the purpose to create awareness on the cyberspace. SAIC also partnering with many educational institutions, colleges, by opening student chapters, SAIC student chapters to nurture the student as cyber-savvy citizens. So this is about SAIC. Let us talk about this award function which we have last week. Last Saturday on 17th December 2022, SAIC, in association with Exnora and SPIN, honored 4 eminent personalities by presenting them with the Lifetime Achievement Award for their commendable contribution in the cyber world or space. Justice D. Bharata Chakravarti, Madras High Court judge, was the chief guest and presented the Lifetime Achievement Awards to a judge, an investigation officer, and are a cybercrime consultant and a public prosecutor of the first, or I can say India's first cybercrime case. The judge, Mr. D. Arulraj, retired district judge, who has courageously accepted the electronic document as evidence. In one of the articles, our Naavi sir mentioned him as unsung hero of Indian cyberspace. And the next one is Mr. S. Balu, retired additional superintendent of police, who was the investigation officer. And Mr. Umashankar, our Naavi, cyber jurisprudent, who was consultant for the first Indian cyber crime case, convicted successfully. And the fourth one was S. Kodandaraman, retired special public prosecutor of Tamil Nadu. So congratulations. Actually, SAICI is honoring by giving the awards to all of the four. Along with Justice Bharata Chakravarti, there were other district judges, senior advocates, IT professionals, SAICI members, students, and the family members participated and felicitated the awardees. Okay, now why this award to these four gentlemen? So we are saying that, right, this is for the first cybercrime case successfully convicted. Not only that, they are pioneer in the cyberspace by handling many cybercrime cases under IT Act, and including the first cyber crime case, which we are going to discuss in this session now. And also, all are senior citizens, but very passionate and actively contributing to the society by taking seminars, conducting awareness programs, training people, mentoring professionals, and on top of that, continuously learning and enhancing their knowledge on emerging technologies. Otherwise, right, we cannot cope up with this cyber world, right? So today, one thing is coming, at least they should understand that what is going on in the world. Otherwise, they cannot actively functioning or advising or conducting any training, or at least to understand that they should learn. That is what they are doing. And also, right, so their active contribution, like young chaps, also one of the factor for this award. Indeed, SAICI is feeling proud to honor our four well-deserved personalities with this Lifetime Achievement Award, including our Naavi sir. So that is about thing. And also I should thank Advocate Mr. Ranganath for his participation as a guest of honor in the award ceremony, along with his team, and sharing his experience on the Umashankar adjudication case. So that is the note about I would like to say. And again, congratulations Naavi sir, and congratulations Ranganath sir. Thank you.
Thank you. Mr. Nagendra, would you like to say 2 words?
It's really great to have all of them who are all honored by the SAICI here for their achievement, lifetime achievement in the cyberspace. On behalf of FDPPI family, we wish to congratulate all of you who are all participating in the award ceremony. Thank you so much, sir. Thank you. All the best wishes.
Kodandran, sir.
Good evening to everyone. I am happy because I am a co-passenger in this journey. Whenever certain movements happen in this case law, Naavi will share it with me. He will discuss with me, and I wish to learn. In fact, as a student, I followed this case with him, and whenever I meet him, I used to haunt him with this. Probably he was not ready to give because it was not successfully moving on. But still, I used to take inspiration by meeting him, getting these details, and I've used in my couple of articles. The amount of service done by these four people, the judge, the public prosecutor, the expert, and the lawyer, is something to be written in the annals of our Indian cyber history. Especially when it is mentioned that they are senior citizens doing this kind of innovative task of bringing about a new jurisprudence, which is very much essential in the cyber law. It's this law which is futuristic now in its approach, and our Naavi and the entire team has led, which has made our FDPPI also is proud. And talking about our computer, so this Cyber Society of India, I have been follower of this. Also Computer Society of India of Bangalore, which is much more old, I was following it. And in FDPPI was formed, I was much more enthusiastic and enjoyed. And this journey I have undergone as an onlooker, which has fascinated me. And I thank the Computer Society of India for honoring such legends on this occasion. My congratulations to everyone. Thank you. Thank you, everyone.
Thank you, sir.
Thank you. Thank you. Dr. Limaye, would you like to say something?
Yeah, this is a very proud moment for everyone. Since cyber law is, though this is a huge victory from the High Court, because normally adjudicating officers and TDSAT takes huge time, and then High Court deciding or affirming the views as far as the Umashankar matter, and as far as previous matter, Suhas Katti, that was phenomenal work. So both are now trendsetters in cyber law. And as far as myself is concerned, I am always discussing various cases with Naavi sir and inspired by him. So he's always guiding force behind whatever is happening in cyberspace. So again, congratulations to Naavi sir, and we hope your support and guidance will be always there for all those who want something, do something in cyberspace, and also to FDPPI. Thank you.
Thank you, Dr. Limaye. Mr. Rajesh, if you are in a position to unmute, would you like to speak?
Thank you very much, Manju, for giving me this opportunity. I would not want to miss this. So, first of all, sir, thank you a lot. You very well deserve this particular title because, like me, there are a lot many people have been able to get direction in terms of building and setting up the career. So, I don't have anything, and I'm happy to have you. Got you as a mentor, and I'm happy to get associated with the journey and be at least some part of it. And it's a well-deserved one. So congratulations, sir. Yes, but treat to banta hai, sir. Hopefully we'll meet you personally.
Thank you, Rajesh. Mr. Anil Chiplunkar, Mr. Subraidu, Mr. S.K. Prakash.
Hi, Anil here.
Hi, Anil sir.
First and foremost, heartiest congratulations to our Naavi sir for having the Lifetime Achievement Award. And also heartiest congratulations to all the veterans who are felicitated on that day. Only one thing I want to say is, it possibly is a little early time for Naavi sir to receive this award because he is going to have so many more achievements in the life. So probably more lifetime achievements should be on his way. Keep up, Naavi sir.
Thank you. Mr. Subraidu.
Yeah, heartiest congratulations, Naavi sir, Advocate Ranganath here. I think I was a newcomer to cybersecurity law, cyber law, and all these areas. And my first brush with Naavi sir happened with some Isaka Bangalore chapter event where I first heard him talk about it, and I was completely bowled over by the simple way in which he explained the concepts of the legal concept and the fact that cybersecurity is an overlap between technology and law. And thereafter, when I joined FDPPI, and I think for most of us, this is that, you just have to find the right ecosystems and plug yourselves into that ecosystem. And thereafter, you realize that your knowledge is automatically increasing by simply participating in these events and Gyanavardhanis and all. I think FDPPI is one of those remarkable ecosystems into which you just have to simply plug yourself into that ecosystem. But yes, your all challenge is to find this ecosystem? Well, once you find it and you plug yourself into this, then you find that you're automatically enrolled onto a journey of learning. And you look back over 3 years, 4 years that you've been part of FDPPA, and you realize how much you have grown, all because of Naavi sir and this fantastic organization that is put together, which comprises the senior most practitioners and from where you can learn practical aspects. I think this is one of the most wonderful learning journeys that I've ever had so far. And I keep recommending it to each and every single profession that I come across. A very, very unique organization, and all thanks to the vision of Naavi sir. He is the glue who sticks all of these things together. Very fortunate to be a part of FDPPI. Thank you, Naavi sir, and thank you, FDPPI.
True that. Mr. Guna, Mr. S.K. Prakash, Anirban, would you like to say something? Mr. Guna.
Yeah. Thank you so much. Hearty congratulations to Naavi sir and Advocate Ranganath. And I'm so proud to be part of the FDPI and being a student of Naavi sir. And I really appreciate the contributions made to the industry and communities like us, FDPPI and other cyber law, cyber legal, and data protection, whatnot. So all these communities and industries, definitely they are getting the benefits out of Naavi sir. We wish him all the best. Thank you so much.
Thank you. Mr. S.K. Prakash.
Thanks, Manju, for giving me this opportunity. Naavi sir and Advocate Ranganath, a big congratulations to both of you. And, you know, before FDPPI had started, and in fact, before we had started interacting with Naavi sir, you know, it was more of GAN from Naavi sir through Naavi.org site, you know. After FDPPI got incorporated, you know, the personal meetings with Naavi sir had increased, you know, either physically and during Corona times, of course, virtually. And we all have benefited. And as someone rightly pointed out, Naavi sir has been the glue who has taken all of us along with him. And, you know, looking forward to continue to work and learn more from him in the same fashion. Thank you.
Yeah, Manju, it is always flattering to hear our friends. But I think you should give us some time for discussing the case.
Yes, sir. We just finished. This was.
I was about to say that.
This was meant to be a surprise for Naavi sir, and I hope it was a pleasant surprise and not a rude show.
Okay.
Thank you, everyone, for joining to celebrate this achievement. Many congratulations, Naavi sir. We are honored to have you as our mentor, and many congratulations, Advocate Ranganath. Thank you, everyone. We'll move on to the session. Sir, over to you.
Yeah, I will try to share the screen. Then perhaps we can start. Where is my share screen? Yeah. Okay, good evening, friends. I'm happy to actually share some of my thoughts about these two important cases. Of course, one was the state of Tamil Nadu versus Suhas Katti, which was a criminal prosecution under Section 67. That is what interests us because we are talking of ITA 2000. There was also, of course, two sections of IPC under which conviction happened. In a way, it also, for example, indicated that a conviction can happen simultaneously under certain sections of IPC and certain sections of ITA 2000, as long as there is no double jeopardy. That is, we are not invoking a section of IPC and ITA 2000 for the same offense. It is possible to actually have two different statutes and bring it together. So that was the instance of Suhas Katti, but we will focus more on section 67. Second case was that Umashankar versus ICICI Bank, which also, both these are very, very historic cases. In fact, because it was historic only, I think SIC and others thought of actually using that for also conferring this Lifetime Achievement Award. In fact, the Suhas Katti case perhaps went for only about 9 months, in the sense that that was a criminal case in which I will perhaps share the timeline. Within 7 months, actually conviction happened, and the accused actually was arrested at the time of investigation and did not get bail, and he was there until his sentence was actually shortened by the next court on appeal. But the whole process was about 9 months. It ended in 2004. It created history and it went off the radar. But whereas this Umashankar's case has been a fight for last 14 years, as far as I am concerned, because the incident happened in 2007, and in 2008, Mr. Umashankar, who is an NRI, and his father, unfortunately, his father, who fought all through these 12 years, was actually not available now when the High Court decision came. It's one of the tragedies that many times the litigants actually don't survive the length of the process. So he passed away a couple of years back after the case was in the Madras High Court. They approached me somewhere in 2008 and said, sir, we don't know why no lawyer is taking this case. We don't know what to do. We have lost this. So that was the situation at that time, when the knowledge about cyber law per se was low, and the proceedings of how to take it forward was also less. In fact, even the adjudicators themselves did not know that they were the judicial authorities for the entire state. So many times we had to tell them that, sir, you are the person. I cannot go to a civil court because civil court jurisdiction is not available for this. Only you are the person who has to take it. And fortunately, we encountered an adjudicator who is the IT secretary of Tamil Nadu at that time, one Mr. PWC Davidar, who was very, very knowledgeable in his own sense. And having served as a magistrate earlier, he was interested in taking up this responsibility, and he took it forward. Many other IT secretaries are not so keen. So we were lucky to have him hear this particular case. So I actually, and also it so happened that I was an earlier banker, and I had extensively taught banking law to bankers when I was the faculty member in Indian Overseas Bank Training Center. So the knowledge of banking law, knowledge of cyber law, and the reason that nobody else was taking up their case, and there was a kind of a social requirement, service requirement, I took up that responsibility, and under power of attorney, ran it through the adjudication, and then the Cyber Appellate Tribunal, and then the TD SAT, and finally it landed up in Madras High Court, where again, of course, I was trying to see that I will be given the opportunity to argue out the case, but certain technical reasons and other things and rigidity of the High Court systems said that no, you can only be a consultant. We need a bar member, and that was the time when Mr. Ranganath came in, because even to assist in such cases and take the argument further, we wanted somebody who fully understands the cyber law aspect. In fact, Ranganath has been assisting me in many of the cases whenever. Now I have more or less stopped litigation things, and in Bangalore, whenever I get something, I pass it on to him. Even my Cyber Evidence Archival Center, this Section 65B certifications, I have more or less transferred to Mr. Ranganath, and he effectively handled the last part of this litigation in the High Court. Hopefully, I feel our journey will end here. 14 years are over. Hope there is no need to go back to Supreme Court. But if it goes, I think I will have to only request Mr. Ranganath to take it further. But anyway, this was actually a lifetime, you can say, endeavor kind of a thing. There are a couple of things I have worked on consistently for several years, out of which this is one, which from 2008 onwards, 2010, the judgment came from the adjudicator. Then 2012, we had more or less completed the proceedings in the Cyber Appellate Tribunal, but Cyber Appellate Tribunal itself got almost closed because the chairperson was transferred and no substitute was posted. So until 2018, there was no Cyber Appellate Tribunal in India, and this case got stuck there. Then TD-SAT came in. Cyber Appellate Tribunal was merged with TD-SAT. They immediately took it up in 2018, somewhere in July. They had the first hearing. I attended that hearing, and then between July 2018 and January 2019, TD-SAT concluded the trial because all the arguments, everything had been done earlier. Volumes of documents, including the arguments, written arguments, were available. So January 2019, TD-SAT gave its verdict, again upholding the adjudication award. But there were some issues regarding interest and other things. So we applied for a review, and there in March 2019, the TD-SAT gave its second judgment basically on the interest and other things. Subsequently, ICICI Bank went for appeal in High Court. In fact, the TD-SAT chairperson was a retired Supreme Court judge. So in a way, while the IT secretary was, you can say, is not a full-fledged judge, the Cyber Appellate Tribunal also had a retired High Court judge, Rajesh Tandon, and then this TD-SAT chairperson was a retired Supreme Court judge. So basically, judicial minds had gone through these cases, but still officially, the Madras High Court was the one formal judicial say forum in which this came up for further discussion. And after a lot of tension there, finally, in fact, the initial discussion for 1 year was whether Naavi should be allowed as a party in person and argue the case. So that itself went for some time, and there was a judgment on that also. In that judgment, actually, finally, the court said that Naavi will be accepted as an expert and he will assist the court, kind of a thing. Then, of course, the trial went on after a couple of hearings, and then finally, in November 22nd, the judgment actually came from the High Court. Of course, High Court judgment simply said the appeal is dismissed. What it means is that the earlier TD-SAT judgment actually stands, and therefore we are saying that 3 different judicial fora have upheld the decision that the bank is liable to pay damages to the phishing victim, and the damages could be, one, of course, the money lost, second, of course, the interest, and a little bit of say expenses. In fact, I am not satisfied that the full expenses were not considered. In fact, adjudicator had considered some expenses, taking into account that the victim had to come from abroad several times and other things. But somehow the other courts, including TD-SAT and High Court, did not appreciate the cost involved. Of course, we were working without charging the person, but of course, the expenses such as my travel to initially to Madras and then to Delhi for Cyber Appellate Tribunal, that cost actually the victim did bear. And there were a lot of such expenses apart from the legitimate fees which any legal person should get. But unfortunately, the TD SAT did not consider the expense to the higher extent, and High Court was simply silent. Only the interest portion was added. In case there is any further changes, we will have to see. But it took this 14 years, and throughout these 14 years, the victim was Umashankar, but I think most of the court and other things start that Vijay Shankar is Umashankar. So that was the level of my involvement in this. Maybe it is not right. Legal people will not accept the advocate or the advocate substitute in this case, taking personal involvement in this. But somehow it is my nature, and so I fought this case as if it was my case. And so we went through all these years of, say, ups and downs. In fact, even the adjudication, this thing came as a surprise. We made all these presentations, and I came back to Bangalore, and suddenly one day I got a call from the father of the victim saying that adjudicator has given 12.85 lakhs. It was a surprise to me. Then again, TD said also, when the first this thing came, I was very much upset because the interest portion had not been considered. So it was not beneficial in that sense. But fortunately, they reviewed the case, and based on the review, something happened. And throughout this period, it was not easy to convince or say inform the judicial people about the nature of this crime, the fishing as a thing, and the kind of loss. Even today, I don't think the judiciary has really understood that in this particular case, the money had gone out of a non-resident external account, NRE account. Those are few who know banking. Now, NRE account consists of repatriable funds, which means that the 6 lakhs which the person lost in the year 2008 had a certain dollar value, and he was entitled to repatriate it in terms of dollars on that day when dollar rate was 45 rupees. Now, if the money has to be given back to him, he should be put in such a situation that his $45,000 of that day or whatever was that should be provided. But dollar today is 80 rupees. So there is an exchange related difference. This is apart from interest difference. So interest and the exchange difference. I don't know whether the court has really understood this. So this is part of our written arguments which we have provided to the court, because if tomorrow ICICI Bank writes a check for whatever amount, 6 lakh plus interest or something, and hands it over, that money cannot be credited to the NRE account. It will go to an NRO account, which is non-repatriable, and taxation purpose, it will be taxable in India. I will have to run around Reserve Bank of India to see that that gets into the repatriable account. So this case was unique for several such reasons. One, not only for the legality of the whole issue, but for accepting an external person as a person who is allowed to say represent the person under a power of attorney in various forums. Then this question of how to calculate interest loss and how this exchange loss has to be done. All these things actually is part of the case. And that is why I say that cyber jurisprudence has been developed in this particular case. I will request Mr. Ranganath also to say a few things, and then we can go into more discussion later on. But before I hand it over to Mr. Ranganath, I will say a few things about this Suhas Katti case, because you all know that the whole world of say the legal people, they recognize Section 65B only when the Bashir judgment came from Supreme Court, which was somewhere in 2012. Now, from the year 2000, when I wrote my first treatise on cyber laws in India, that's Information Technology Act, because I started my cyber law college way in July 2000 itself. I have been saying that the section 65B certificate has to be given like this, and it can be given by some external party and so on. But until 2004, there was no opportunity to test it in the court of law. So in this Suhas Katti case, you understand that the Suhas Katti case was a very tough case in the sense that it was the object of crime was a message which had been posted in Yahoo group, which means that we are talking of an electronic document which is lying in the Yahoo group server somewhere in USA. There is no way police can go and seize the hard disk and bring it to the court and say, here is the electronic document, here is the evidence for, say, the crime. So, but I've always been telling it is not necessary. In fact, I've been telling forensic people that it is not necessary to seize a hard disk for the purpose of cybercrime investigation and presentation. What you have to seize is the electronic evidence which lies inside a computer hard disk in the form of binaries, and that binary can be read by using appropriate application and device on a screen, and then you can take a printout and then certify it under section 65B, and then that electronic evidence is admissible in a court of law without the production of the original. Now, this concept, many lawyers have even today have not understood and accepted. Everybody asks, where is the original? Without the original, how can you bring this copy? In fact, the whole section 65B, along with these earlier sections of 65A, as well as 62, 63, and going back from to section 3 and 17, 22, etc. If you look at all these sections of Indian Evidence Act, it is very clear that whoever had thought of this section 65B did it with full understanding that electronic evidence is very difficult to grab and bring it to the court. So at that time, it was easy for an academician like me to give lectures saying that there is no need for original, whatever certificate I give should be admitted, etc. But for that to be accepted by a magistrate, it was something which was very, very commendable. You remember, after 2004, 2005, there was a Supreme Court case in Afzal Guru, and there the Supreme Court judges did not have a full understanding of section 65B. So 2012 Bashir judgment, the three-member judge bench actually clarified what is the section 65B, why it is mandatory, and presentation of evidence at admissibility can be different from presentation at a later discussion on the genuinity of the document. At the time of admissibility, it is enough if a properly certified section 65B certificate along with the evidence is presented. Subsequently, the other person can challenge, and if the court wants, they can take the assistance of a digital evidence examiner. All these things came to be understood only after the Bashir versus Anwar judgment. But even afterward, we had the Shafi Muhammad case in the Supreme Court, who did not agree with the Anwar Bashir judgment. They tried to give another meaning to the section 65B requirement and came up with a bizarre argument that section 65B is required only when the device in which the evidence is present with the person who is producing the evidence. That is, if there is, yes, I've got a laptop and the evidence is in the laptop, I can give a section 65B certificate. If the evidence is in Facebook or some other place, I don't have that with me, I cannot give a section 65B evidence. This was the crazy judgment which was given by Shafi Muhammad case, which was absolutely wrong, and which meant that even at the highest level of the land, discussions were still going on. But Mr. Arul Raj a small-time court magistrate in 2004 appreciated this and accepted, admitted, and then went ahead and gave a decision which actually resulted in totally 2 + 2 + 1, 5 years imprisonment in this Suhas Katti case. So he had that conviction. And this was not a one-off case as far as this person Arul Raj was concerned. Why I some time back said he's an unsung hero. There was, after this particular case, these are something which I think the advocates and others will find it interesting. After this, there was a case called Trisha defamation case. In that also there was another jurisprudential challenge which came. In that case, the police had submitted a CD containing whatever was the object of crime to the court. So the magistrate was having in his hand a CD, which everybody else would say, this is the electronic evidence. I will take a view on that. I will put it in my computer, see, and take a decision. But this person, Arul Raj, knew that that was not the right way the law intended evidence to be presented. So he invited me to his chamber, asked me to view that CD, take the printout and give a section 65B certificate, then take that as part of the exhibits for the particular this thing. So he had a sort of an whether conscious or unconscious, I don't know. He had an understanding of the section 65B, which I have been talking for such a long time. I am telling that if the judge sees this thing and takes a view, then he becomes the witness. So he cannot be a section 65B certifier. So even if the object is presented before him, he should get it converted into a section 65B certified evidence before he can proceed. So this person, this Arul Raj, had the appreciation of section 65B at a level which many senior judicial persons did not have until 2012. After 2012, when this Shafi Muhammad came, and subsequently in another case called Pandit Rao or something like that, this was again reversed. So that is the historic nature of this case, because this case sometimes is a question in many of the law colleges, both this Umashankar case and this, and there are these very important cyber jurisprudential issues here which can be debated, and that is why these cases were relevant for this kind of an award, not just because they were the first cases. Apart from first cases, there were something which are very well established here. It was fortunate that I, as a consultant, will be talking about this, but for the IO to accept my argument and take it further, and for the public prosecutor to take it for his argument, and the judge to accept, all these four people thinking of the same thing is not easy. Okay. So, but that happened in the Suhas Katti case as a coincidence or whatever is that. Same way, Davidar being there as the IT secretary, when I was explaining about digital signature not being used, being one of the issues, and then this Shivakirti Singh of TDSAT, where he agreed that section 43 subsection G, which talks about assistance for committing a crime also being a crime. He accepted that and said the negligence of ICICI Bank should be considered as passive assistance to the commission of the crime. And he has quoted 43 subsection G. And I think that also required some kind of accepting a new thought, because everywhere when we discussed ICICI Bank case, the first thing would come, the victim has given away his password. What kind of, even today you ask people, how did the court give the compensation when this person has given away his password? That is where all other things which we discussed about, say, an incident in which there are multiple people involved and negligence is of multiple people, then the person who was the proximate cause, so the last person who actually could have prevented the fraud, did not do so, should hold responsibility. In this case, it was ICICI Bank, and ICICI Bank had not followed the security guidelines under internet banking guidelines, the Gopalakrishna Working Group regulations, the established principles of banker-customer relationship from the case of Canara Bank versus Canara Sales Corporation, the case of the CERC versus LIC of India, which is unconscionable contract. These were all actually brought into it. And because I was an unwritten expert in banking law, I could get all those things into the arguments. And that is how, whether it was the IT secretary or the TD said, nobody could refuse because in many cases, particularly in the cyber tribunal, I had opposing me a senior advocate who later on became the judge of Delhi High Court. So you can imagine that he must be a very senior person. And in TD SAT also, ICICI Bank brought senior counsels only for argument, not only for this thing, for argument alone, they brought one senior person and all. But still, I was fortunate to convince the judiciary, and that is what gives some kind of a satisfaction for me. Maybe you can say I have got something more to do in data protection, but at least in cyber law, I think this is a very, very important stage of achievement. I am happy. And anyway, cyber cases, I'm not shifting to others. So my lifetime, as far as cyber law is concerned, yeah, my teaching and other things will go on, but I may not be very much involved in the litigation work. So that is fine. Then, of course, we have this data protection, maybe in neuro rights, I will continue to work on this. So this is the background of this particular case, which most of you should appreciate. Now, if Ranganath permits me for 2 minutes, I will run this video. I found this video on the YouTube, which actually gives an animation of this particular case. Shall I play this, Ranganath?
Yes, sir. Yes, sir. Please go ahead, sir.
State of Tamil Nadu versus Suhas Katti, Section 67 of the Information Technology Act 2000. Suhas Katti was a family friend of Miss Roseline and wanted to marry her. But she rejected him as she was in love with someone else. And she got married. Eventually, their marriage resulted into divorce soon. After her divorce, Suhas Katti persuaded her again to marry him. But she said no. On her reluctance to marry him, he took the course of harassment through the internet. Suhas Katti opened a false email account with her name and posted defamatory, obscene and annoying information about her. Then Miss Roseland filed a case against him on the basis of being harassed. A charge sheet was filed against Suhas Katti under Section 67 of the IT Act. Section 67 of the IT Act states that whoever publishes or transmits obscene material in electronic form shall be punished. Finally, Suhas Katti was subjected to rigorous imprisonment of 2 years along with a fine of ₹4,000 under Information Technology Act. Thank you for watching. Kindly like, share and subscribe the video.
So this was the case, and I think now I should ask Mr. This is the 3 sections under which he was punished. 2 years under Section 67, 2 years under 469, forgery, 1 year under 500. This forgery was because at the end of the Yahoo message, he had written this Mary's name, Rosalind's name, and also in the cyber cafe also he had written her name. So that was considered as forgery. This is the timeline. Commission of offense February 7, 2004. Within 1 week, the lady lodged a complaint, and the accused was arrested on within 4 days from the date of the complaint. And Mr. Balu Ivo actually went all the way to Bombay, getting whatever permissions he had to get from his department, and then caused the arrest. And this judgment came in November. So that's how sometimes we say that a criminal case can be over in 9 months, or is something which is very important. Okay, so I leave it now to Mr. Ranganath. If any other material is required, I will try to supplement it. Okay, Mr. Ranganath, if you want, I will take out the presentation.
Let it be there, sir. Let it be there. Case study Umashankar versus ICICI Bank, because I don't have any presentation. Thank you so much.
Okay.
And thanks to FDPPI and thanks to Cyber Society of India, both in identifying the lifetime achievers, the greatest legends, the 4 people. Thank you so much for that. And thanks for us to be part of the program which was conducted in by Cyber Society of India in Chennai. Now, sir, as you spoke about 65B, even today in courts, people don't know how to submit 65B certificate. They think it's a affidavit. Some people are submitting as an affidavit. Some people are giving it as a certificate. And there are no system details. There are no IP addresses, etc. But it has taken a shape. Courts are asking for 65B certificate, which started from Suhas Katti case, which you have issued. And recently, it has been confirmed by the Honorable Supreme Court also. 65B is mandatory. So a little bit on that. Now coming to Umashankar case, it was really a challenging case, especially in the High Court, where the argument went for half a day. Even Naavi sir was there in the court hall. I'll come to that later. Now, when we look at the facts of the case, so what was the fact of the case? Umashankar receives a phishing email link telling that they are upgrading the security of the banking system. And in case if he is not updating his details, his account will be blocked. And there will be 2 additional links. So he'll click on the link, it will ask for user ID password, he'll provide necessarily. And subsequently, there will be 5 transactions, 1 lakh each and 1,46,000, totally 6,46,000, he'll lose the money. So this is the issue which happens on the day 1. And the Umashankar will not realize. On day 2, ICICI Bank, day 2 evening, they'll give a call. They'll call Umashankar and they'll ask, have you done this transaction? Immediately he denies and he'll lodge a complaint. That's where the case begins. He'll lodge a complaint with the bank telling that, yeah, I have not done these transactions. And the bank, further, they'll have their internal inquiry and they'll ask him to lodge a complaint. Similarly, he'll go to and he'll lodge a cybercrime complaint. From their investigation, from the criminal part, it begins. The interesting part was the money which was taken out from Umashankar ICICI Bank goes to another ICICI account, which is a dormant account. There is a current account which was not in use for 2 years. So, which is a account which is not in use for 2 years. All of a sudden, there will be a transaction of 6,46,000, and the person who is the account holder, he'll immediately withdraw very next day. 4 lakh rupees he'll withdraw by giving a check. Now, what issues ICICI Bank would have done? Like we have, Naavi sir had fought for almost 10-12 years, and he has repeatedly told ICICI Bank should lodge a complaint in Mumbai immediately. When the amount was withdrawn, bank knew the amount was withdrawn and the CCTV footage would have been secured and the police would have arrested the accused, and whatever money was in his hand, they could have rescued. They did not do that. That was the first thing. Second thing, CCTV footage till the end, they did not give. And the third thing is one of the ICICI official, he'll send from a Gmail account of his Gmail account to Umashankar, giving certain details of internal inquiry, whatever they did. And finally, they'll come out with a conclusion. It's a phishing mail and you have compromised the user ID and password, which is very confidential to your account. And you have signed the consent form while opening the bank account. So this is the stand which bank had taken. Since you have, since everyone is aware and we have repeatedly told you should not share your, this is in the year 2008, what we are talking about. And you have shared your user ID and password, so bank is not liable, you are liable. So that's where everything started. And when I saw the arguments which were submitted by Naavi sir in adjudication, there's a couple of technical things which was brought up. One is the criminal part where bank should have taken the responsibility and they should have lodged the complaint. They have failed. That is the first thing. Second thing, CCTV footage, which they had evidences in the first place. They did not submit, they acted on that. That was the second part. And the third part was, which went to the dormant account. In that dormant account, there was a overdraft. There was an overdue of 35,000 rupees. So what ICICI Bank did was, as soon as the 35,000, 6,46,000 they took that 35,000, which was overdue in that particular account. So these were some of the highlights which Naavi sir had highlighted. Along with there was no digital signatures in the emails which were sent. and many other technical part. So this went on from adjudication to TD SAT. From there, it traveled to the High Court, the Madras High Court. So here, the challenge was we prepared all our arguments with definitely inputs from Naavi sir. He gave all the directions. So me and my team prepared. And when we went with our argument, we had a surprise in the court. I'm talking in the ground level what happened on that particular day. So there was a senior counsel which bank had appointed in order to argue from the bank side. Similarly, they took a stand of these things. It was a phishing mail, and compromising the user ID and password was what is that mistake of the customer, and they have signed the form, they submitted the forms, and they gave hundreds of pages to the court, the application form, starting from application form with all the communications, emails, and other things and all. So one stand was the negligence from the customer. That's the thing they took. Second thing, technically they said the email would have been sent from any simple mail transfer protocol, SMTP. So anybody can send a mail. With that, it is the duty of the customer to identify the phishing mail. This was the second point. So to our surprise, the honorable judge who was hearing, she took 5 minutes to read the entire thing, and then we were fired with a lot of questions. Of course, Naavi sir was also there. Even Naavi sir gave his expert evidence for almost an hour plus. He talked about the banking and the NRE account, especially how does NRE account works, and how this issue happened, and various other things. From our perspective, under IT Act, there is something called reasonable security practice under 43A, failing to which the bank would be held responsible for the damages for the wrongful loss incurred by a person and a wrongful gain subsequently for another person. So what was our line of argument was, because the mail, if we see, it has come from customercare@iciicibank.com. And the questions which rose was, generally mail for a NRE account, a signature will be coming from NRI services. But in this particular mail, that NRI services were not there. That was the first thing. Second thing, they said technically the customer should have seen the mail. But the customer should have seen the mail. He did not see the name because there was a slight change in the name. And for this, to counter this, what we said was, one was the reasonable security practice failure. Our strong argument was ICICI Bank had a capability to identify any higher amount of value transactions, because it is very evident the very next day they made a call. In case if they have done this call one day earlier, when the 1 lakh initial 1 lakh transaction happened, then this could have been stopped. Rather than 6,46,000, maybe the loss would have been 1 lakh at that point in time, and that could have been dealt in a different way. That was the first reasonable security practice. They failed. Second thing, the server is not that easy to not that easy to open another website similar to ICICI Bank. For this purpose, again, we provided a 65B certificate. We went to GoDaddy, Who is Who, and we downloaded the registration details of ICICI Bank. That was duly submitted to the court to show that this server cannot be duped, or it is not a case of a cyber squatting. The senior counsel was arguing it was a case of a cyber squatting. We had to say that it is not a case of cyber squatting. And subsequently, the two further links which had come, the subdomains, that was also part of ICICI Bank. It had verification certain things at ICICI Bank. Similarly, these were the two things. And the third point, 43G, which Naavi said, giving any assistance to fraudulent transactions using computer system or computer resource. So in this regard, our argument was, since the money which went to a dormant account and they have taken that money, in the CRPC also there is a provision, who is any stolen goods or stolen money is also, that person is also liable. That was the condition what we took, and we heavily argued on that part also. And since ICICI Bank knows it is a illegal transaction which happened, even though they knew this was an illegal transaction, they have taken this money. So they didn't have any authority to take this money. That was the initial line of contention. Especially it went for almost second half was full of this argument on that particular day. A lot of questions were there and a lot of firings were there at us, me and Naavi both. So finally it resulted in even in the judgment, if we read, It clearly says ICICI Bank should have been responsible and they should have given a complaint, and whatever the line of arguments which went for 14 years, that has been upheld. That has been upheld, and so that's how this travel went. Rather than taking more time, it's already 5 minutes overshoot. I have told in crisp summary of the case. And from my team, Sripati from Chennai was there, and Chinmay, who gave 65B, she was there. Of course, Naavi was the lead in this case. And it's a remarkable experience and remarkable argument what we had on that particular day. So thank you so much. And one more thing I would like to say. I was a first batch student of postgraduate diploma in cyber law, cyber forensics, when Naavi was a faculty. At that time, when I studied Umashankar case, I never thought one day I'll be doing the argument for the particular case in the Madras High Court. Thanks to Naavi and all other faculties. And of course, Kodan Ram sir is here. He was also my batchmate in CLCF. And thanks to Durai Kannanian, that is the Cyber Society of India, for recognizing really great legends who set the cyber jurisprudence into motion. When IT Act came in the year 2000, it was hardly any identification of electronic records. And 2008 with amendment, they brought a lot of criminal aspects to that. And 65B certificate, the journey started by Naavi sir. It's just taken a shape with the recent judgment which has come. And now there is some traction which is happening in the jurisprudence of cyber laws. Definitely it'll take a step further. Thank you so much for giving an opportunity to share the arguments and the details of Umashankar, what we went through. And I'm thankful to Naavi sir, FDPPI, and all others who are here. Thank you so much.
Thank you. It's also interesting to remember that Mr. S. Balu, who was the IO, he was also my student in the first batch of training, which we conducted to Madras Police. Okay, way back in the year 2000. Okay, so then of course he became the cybercrime DSP, and we worked together. So sometimes teaching helps.
You can say it's a family affair.
Okay, fine. Any questions? As Limay has pointed out, see, this incident happened in 2008, June, and the actual incident was 2007. So 43 capital A actually came subsequently. So we had to work under section 43 and the due diligence aspect, which was referred to, and the internet banking guidelines under the SR Mittal group of RBI, which was very important, because that was actually accepted, and then internet banking guidelines had been issued by the Reserve Bank of India. There it had been clearly mentioned that the responsibility for not using digital signature, the legal responsibility is that of the bank, it had said. So therefore, it was an RBI also had said that in case the banks are compromising on any of the securities because the technology is not ready, etc., then they have to take the legal risk. So we used that. And then when Gopalakrishna working group came, ICICI Bank did a lot to get the committee give out a report to say that this OTP and other things are equivalent to digital signature. They wanted to overcome this digital signature argument. And in fact, this case has been mentioned in the Gopalakrishna Working Group Committee report, where one of the executives was also part of the committee. Okay. Then I had to take it up against RBI quite vehemently, saying that if you tinker with what is there in Information Technology Act and declare that OTP is digital signature, then RBI will have to answer in the Supreme Court. Okay. Fortunately, they actually, the entire chapter they had put as a draft on in the Gopalakrishna Working Group Committee. They just dropped it and removed it in the final report and said whatever has been there in the Internet Banking Guideline of 2001, there is no additional report of the Gopalakrishna Working Group Committee, which came actually in 2011. In fact, they are all the side stories in this case. And tomorrow, if somebody writes a whole story of this, there is so many things which can be brought in for the purpose of education And of course, it is. I understand that everybody cannot fight a case as passionately as I could have done here. I had no other work, then perhaps I did this kind of a thing. But I think that is what we owe to the victims if we want to achieve something. Okay. Any other questions? I think some students of law are also here. So,
Sir, just before that, there was one more case we have won. The last week judgment came out. We didn't take it to IT secretary, but we went to consumer court against SBI. This is also a cyber case where they didn't provide any logs or anything. They said the client is responsible. But once I get the judgment copy, I'll send it to all of you for your reference. But just to update, there is one more cyber case in Bangalore settled against ICICI Bank.
Yeah.
Okay. One question quickly. Does it mean the bank system was not having the identification capability to identify those dormitory accounts?
No. See, that was a KYC failure. See, at the credit of the money went to Bombay Fort branch, where that Muhammad Zulfikar Khan had opened a current account in the name of Uday Enterprises. You understand? Okay. And there was a KYC for that. In fact, I have used that as example of how KYC should not be done. He had given an address in which he was not present at all anytime. The bank had taken that address and then opened the current account and then granted overdraft for him. And some of the ICICI Bank people have signed on their application forms saying that this particular account is worth 40 lakhs turnover or something like that. Okay. Ultimately, when the account was to be opened, that person gave a check on IDBI Bank, which bounced. 10,000 rupees check he gave, it bounced. Normally, as an ex-banker, if a check we don't accept for opening the account. If it bounces, that is the first thing we say, oh, you are an undesirable client. But they opened a zero balance account for this person and represented this check after 1 month, got it in cash. And after 10,000 rupees came, next day he came and withdrew 9,900 rupees and left only 100 rupees. That kind of an account they maintained for 3-4 years. And the only transactions we could see in that particular account was sometimes suddenly 1.5 lakhs or something will come, next day will come and withdraw, which means that he was running as a mule for this kind of a transaction, not only for this, but for many other cases. That is why we were able to, even today I can strongly say there was an absolute KYC failure from ICICI Bank at the time of opening of the account and then subsequently granting them the overdraft and then not seeing the transactions, because that is classically what is done in AML kind of a thing. So on that portion itself, ICICI Bank Fort branch would have to take responsibility. Whereas at the other end, this Tuticorin branch, we said that the not using adaptive authentication, like not identifying that 1 lakh transactions was an unusual transaction. They should have done something about it. That is what today we are calling as adaptive authentication. RBI wants them to do it, and they did not have that. They didn't have an SMS alert. So in fact, ICICI Bank introduced SMS alert after 2 months of this incident, saying that it's a paid service. If you pay something, I will give you SMS alert. That was the time at that time. Okay, so there was negligence on the part of ICICI Bank. Then erasure of the CCTV footage, I said this is a section 65 offense. That is, there was an evidence. The evidence was known to be the evidence of a cognizable crime. And they had sent an email to the client saying, please wait for 30 days. We are going to investigate. Then afterwards, they said CCTV footage is kept only for 30 days. You didn't ask me before 30 days, so we have erased. So we said that this was a conspiracy between the customer service person who said wait for 30 days and then said it has been deleted after 30 days, because the security department of the bank on the second day itself had said there is a CCTV footage, this has to be examined. Okay, so internally one part had recognized the fraud, the evidence, but another part they had actually erased it. So I called it as a section 65 offense, 3 years imprisonment for the ICICI Bank officials. But this court's adjudication court was not a criminal court, so this was not pursued. But the adjudicating officer did make a mention that there appears to be a recklessness on the part of ICICI Bank. And so if a criminal court had been there, they could have actually taken it into criminal punishment for ICICI Bank. Okay. At that time, despite my insistence, the police in Chennai, the DGP in Chennai, they did not take up the case against ICICI Bank in the charge sheet. If they had taken it, my view was bank would have paid back the money without going through this process, because it was a civil proceedings, they dragged it on. And remember, one more thing, in our adjudication, the first respondent was ICICI Bank as an entity. Second respondent was manager Tuticorin branch, where we had an account. Third respondent was manager Fort branch, where the money was laundered. Fourth was that Mr. Zulfikar Ahmad Khan, whom the ICICI Bank says is the fraudster. For me, it is a hearsay. He was the fourth respondent. Fifth respondent was the CISO of the bank for not initiating appropriate security measures as per the internet banking guidelines of Reserve Bank of India and Gopalakrishna Working Group Committee guidelines, etc. Sixth was the chairperson of ICICI Bank for not having a system of compliance in the organization. Okay. Of course.
Sir, commendable, sir. There is no question, but I have a point to mention here. As you are narrating, right, because I was not aware of that these many steps and things are there in this case. Actually, when we are inviting, when we are approaching the chief guest, Mr. Justice Bharata Chakravarti, he was asking for the judgment copy before come to the function or event. So it seems that he had reviewed the judgment and case thoroughly, and even in the event, maybe not for the entire group, I'm telling. Actually, he commented this case as an example, and it has to be reported in the courts of the state as an example how a cybercrime case should be handled. The way they framed the charges and the way they have given the technical evidences and making the judge to understand the nuances of the law and technicality, everything is in detail. So the judge uploaded the judgment and the case as like anything, and he finally said that this should be reported, because I don't know what is the meaning of reported, but he was mentioning that in the function and the award ceremonies team. So that is what I would like to mention.
Yeah, I've given links to all these judgments in my website itself. People who are interested can go through that. And in fact, some research students should do a complete dissertation on these cases. There are even an assignment. There is enough information. Maybe I can explain more, say not in a seminar like this, or we have only half an hour, but if you go through all the arguments and other things, there can be a lot more things to debate. And the counter arguments from the other side was basically on the agreement. They said there is an agreement on the website, and the person has agreed, internet banking agreement. It says that any responsibility for lost password is that of the customer. And in fact, it says the customer indemnifies the bank against unauthorized access. I said that unauthorized access by definition is a crime. Nobody can give an indemnity for committing a crime. So the particular agreement was not proper, and that is where we raised this CERC versus LIC of India unconscionable contract provisions, to say that that 23-page document which is there in the ICICI Bank website does not constitute a valid contractual agreement with the customer. Even if it says that the responsibility is that of the customer, we will not accept it. So these are all other things which from the legal perspective expands the jurisprudence which was presented in this particular legislature in this case. And we also presented many cases on the insurance side, this proximate cause kind of a thing, and because they took 35,000 rupees, whereas the balance was taken by this fraudster. But we said in a criminal, say, sharing of proceeds, if there are partners in crime, then any one of that person is individually responsible to repay the entire amount. So if this had been taken on the criminal case, there also ICICI Bank would have found it difficult to justify, because they said 35,000 rupees belongs to them. That was a big mistake they had done. They said that they will exercise the right of set-off, and we said right of set-off cannot be exercised for money which does not belong to the customer, and it does not belong to the customer. The ICICI Bank also agrees, and they returned part of it to us. So knowing that the money which they adjusted to their overdraft account was stolen money, they had taken a benefit out of the fraud, and therefore they simply had no defense actually. But my problem was how to make the judge listen to me. I cannot be, it's not like this kind of a crowd where I can explain from beginning to end. You know, many courts don't even allow you time to actually explain. So that is where we had to resort to a lot of written arguments. And I wanted it to be a record there, so that when it goes to appeal, at least we can say this was raised and then it was not considered. So that is why I say that these particular judgments are not just because they were the first, they are important. They did discuss a lot of issues on banking law, contract law, and IT Act, the guidelines of RBI, and all these things were a part of this, and that requires perhaps a research-oriented person to actually go through that and then document this. Documenting the Umashankar's case is something which is actually a big task. Okay.
Sir, does the bank do not do kind of a review of unusual transactions in the day closure?
They do. In fact,
they should have been found in
during
that time, right?
Software is trained through artificial intelligence to actually raise an alarm immediately.
Today's okay. Today's okay. But banking law perspective, I'm talking. So don't they recommend to do a review or kind of an unusual transaction before you close for the day? It could be manual also, whatever it is.
In fact, they did it on the next day. In fact, next day,
the
bank recognized. Only thing is that was 24 hours too late.
Okay.
By that time, the person had withdrawn 4,60,000 rupees. He did not come to withdraw the balance 1,50,000 because I think he had been sounded by somebody in the bank saying that my security department had already raised a red flag. Come to withdraw the next 150. Okay. Otherwise, he would have withdrawn that next 1,50,000 also.
Okay.
Okay. These are all, you can say in a criminal case, if I am building a theory of the crime, I will put all these as possibilities and stories, and the police actually should have examined this. Why did this person took 4,60,000 on day one and did not take 1,50,000 on the next day, even though it was available? At the end of the second day, evening only, the bank contacted the customer. So that full working day was available for withdrawing the money. They did not withdraw. This person should have been cross-examined, and if he had said, no, somebody from the bank gave me a call or something like that, the bank would have been more responsible. Okay. Yeah.
The question on the similar lines.
One minute, sir. Today, what Mr. Nagendra said just now, even today also banks are not following any velocity check or etc. guidelines in this online banking, because yesterday only I argued 64 transactions of 10,000 identical transaction happened between 2:3 a.m. till 5:5 a.m. in the morning. 64 identical transactions.
Yeah.
And bank didn't had any mechanism at place to alert either customer or to stop those transactions. And bank is coming with the defense that for 24/7/365 customer should be alert, since banking transaction is 24/7 365. So the mechanism which is mandated by RBI regarding velocity check, high volume transactions, etc., are still not followed by the bankers. And Central Bank is involved in this particular case. Judgment is awaited within, say, 1 or 2 months. I'll be able to give this particular judgment to you also.
Which bank is that, sir?
Central Bank of India, 64 transactions, right from 2:03 a.m. to 5 a.m. And the lawyer is arguing that after 2 or 3 transactions, customer should have informed the bank. These are the level of arguments coming up from our fellow lawyers in the court of law. So this is for your understanding, whoever is present in the seminar, how foolishly we lawyers also are arguing courts.
Mahendra, you're right. Even I have a case where it happened during the similar time, in the midnight, 1 to 2 o'clock something. 44 transactions happened, and the fraud is about almost 1 crore. That is going on. Possibly, we'll also get a judgment in 2-3 months. If you get a judgment earlier, kindly pass it on. We'll refer the judgment.
Sure. It will help everyone.
In fact, in another Punjab National Bank case, same thing was there, 35 transactions. Okay. Then the bank gave us a extract of their server showing the time. And it was very evident that the bank had manipulated that log record, because the sequence of transactions there was not in accordance with the time. So I actually said that, in fact, they're all criminal offenses. Only thing is the adjudication is not a criminal court. Otherwise, these bankers who do not know the law and simply think that whatever they say customer will accept will have a lot of problem. I am an ex-banker, so I am having the right to criticize the banker. Okay. Yeah. Okay.
So which means totally preventive mechanism and detective mechanism totally failure. That is accurate.
Totally failed. Yes. Yeah. So that is the lesson for information security people.
Correct. That's what I want to say. IT guys basically are working on the designing of the systems.
All these banks are ISO 27001 certified.
See, to be honest, these are only checklist exercise which the bank do and get the certificate. That's the problem. They don't implement in true spirit of the implementation.
Yeah.
I faced this problem with some banks where I advise them to implement ISO 27001.
Sir, we can have one more session on the negligence of the bank. I'll tell simple thing.
I have run training programs on KYC showing this account opening form, how negligent they were, in fact, to Standard Chartered Bank and others, without quoting this particular case and other things. In fact, today, ICICI Bank is a protected system under Section 70. What it means is that CERT-In is now responsible for the security of ICICI Bank, HDFC Bank, Bank of India, Punjab National Bank, and Bank of Baroda. These 5 banks have been declared as Section 70 protected systems. So tomorrow, when something like this happens, Mr. Limay, please call the CERT-In as one of the parties. What are they doing for this? It's not simply sending a gazette notification saying that it's a protected system. Okay. Now, what is the protected system? This CERT-In representative should be there in the Apex committee of the bank's security team. And all policies should be actually vetted by the CERT-In. So this development also should be used by you people, lawyers, in the subsequent arguments. That is, those frauds which happened today after this Section 70. Yeah. Okay. There are so many things to discuss. I think we have taken complete time. So I think, Manju, you should try to close it.
Yeah.
We will have, in fact, this is something which can go for half a day, a full day in legal circles, actually.
We'll have 2.0.
Okay. I wanted to highlight because why a Lifetime Achievement Award is relevant for such a case is what I was trying to highlight. Okay.
Yes.
And other details, of course, it is for security people and others to actually draw the lessons and convert it into a document. Yeah, go ahead.
Thank you, Naavi sir, and thank you, Advocate Ranganath, for explaining these cases to us. It was a great learning for all of us, and we were equally excited to see how the case unfolded. Thank you so much, and thank you everyone for joining. Thank you so much. Good night.
Thank you very much.